When you started in practice in 1970, hospitals were appealing reimbursement issues and were represented by CPAs and consultants, not attorneys. Tell us about that and the role you played in getting attorneys involved.
Well, the developments that were taking place at the time with the CPAs were representing the hospitals before the Provider Appeals Committee, which was a Blue Cross arrangement. Blue Cross was there. And they basically, I had the first case in 1973 in which a court took jurisdiction to review the Provider Appeals Committee decisions. And then at that point, the CPA firms realized that they had to have a record developed before the committees that would withstand scrutiny in federal court. So that's when the attorneys started getting involved in representing hospitals before the Provider Appeals Committees. So that's the initial part, and then as a result of that, I was already involved in the American Society of Hospital Attorneys, but I became a speaker at the various occasions, and so it was interesting. But I started switching my allegiance to the National Health Lawyers Association because the information that we were getting from the National Health Lawyers Association was more timely. It was a monthly newsletter that the executive director of National Health Lawyers paid 2 young attorneys to research cases and put out a monthly newsletter. People were collegial with the Society of Hospital Attorneys and shared information. In fact, Jim Ludland, the first president of that organization, had put out a sort of a guide for hospital contracts with hospital-based physicians, and we all used that and cribbed from it, and it was very, very useful. The NHLA then started having annual meetings just as the Society of Hospital Attorneys had annual meetings. But then NHLA started with a tax conference that people went to for nonprofit institutions, and that was very useful.
Was it the Society of Hospital Attorneys or the Academy of Hospital Attorneys?
The Academy came later.
Okay. First it was a society?
Society, and that was a division of the American Hospital Association, just as the various other societies were.
Okay, and I understand from your transcript that in the beginning, the attorneys representing these hospitals were really on the boards of their hospitals, and
often the attorneys were on the board of the hospital, and what they did was often they did not charge for their services. For instance, Tom Barrowman, who sort of organized a Pennsylvania hospital attorney group, and I can distinctly remember him lecturing people to please charge for your services so that this can become a profession that people can follow, and that don't wait for a bond issue or a real estate deal to try to make it up. And that was the practice. Law firms had the hospitals as prestigious clients, and they wanted to keep them.
And they were not charging in some cases and lowballing in other cases.
We were representing at the time Temple University and the hospital, and we were charging for partners' time was $44 an hour, which was lowball even back in the 70s.
Okay, and then your focus really turned to the National Health Lawyers Association. And what was the increased value of that? Why did you find that so important?
The more educational programs, but even more importantly, more people outside of hospital attorneys would attend. You had the various programs. You'd have accountants, consultants, government attorneys. For instance, as I said, I started the Medicaid Institute, and just before it was going to go to print, David Greenberg, executive director, said he wanted to joint venture that with the Society of Hospital Attorneys, and that's when they accepted that, and his reasoning was he wanted to try to get a merger between the two organizations, but that wasn't the truth because he really wanted somebody to share the loss in case it bombed. And J.D. then and I were co-chairs of that institute for 20 or 21 years. But what we would do with that is for every government speaker that we got, whether it's the Office of General Counsel or at the time HCFA, for every speaker, they got 5 free admissions. So you had a lot of government people attending the Institute, and it was very enriching. And they would work, they put their own people on the panels, and it was very useful information.
Well, I'm told it was really a genius idea to have this in Baltimore because you had access to government attorneys and there was a lot of interchange of ideas and that sort of thing.
Not only that, but the HCFA people would not even travel to D.C. to be on the panels, because the headquarters was in Baltimore, so they could come downtown and be on it, but they didn't go to D.C. So that was another reason for having it in Baltimore.
Okay. Before I move on, I want to ask you about the society was more limited, and the reason the society was limited was why?
Well, one reason was that it was for hospital attorneys, because it was a division of the American Hospital Association. And at the time, many of the attorneys who went to the annual meeting of the society would manage to get the hospital to pay for them to go. And it was usually a family affair at some place like Camelback. I remember we had one there. Everybody went after school was out the end of June so that it could be more of a vacation. Whereas NHLA meetings were always in a city, not at a resort. And it was all work, not a lot of play.
Okay, tell us about the Academy's meeting in Maui the year you were president of the NHLA. Right. That was sort of a significant moment, I think.
Well, we went to that, my wife Betsy and I, on our way back from Hong Kong, and probably wouldn't have gone but for the fact we had to pass through Hawaii then anyway. But they had, it was rather stunning. They had, the society always had a prom at the last night, and with a band and dancing, and it was always a very nice affair. But this time, they had the tables around the dance floor where the board members and their families and past board members and sort of insiders were all inside this area, and it was all roped off with a gold cord. And you could not get to the dance floor without going all the way around this gold cord. And at the time when dinner was finished and they were going to start the prom, all of the people inside the gold cord got up and went to a private party, leaving all these empty tables and chairs and the gold cord still up. So you still had to go around that. And that later, I think, became the impetus for Bob Johnson, who was the president of the society in 1990 or 91, to push for the merger of the two organizations, because Bob was a client of mine, and I told him about how this had happened, and he thought it was absolutely horrendous, and he said, that can't continue. And that's when he started pushing for that.
And you didn't like it either. Tell us why you didn't.
Well, there was very cliquish, and I never got involved. Maybe if I'd been inside the clique, I might have liked it. But it
wasn't good for the organization.
No, it was not good for the organization. Anybody sitting outside the cord was turned off by that.
And so tell us about the merger and what that meant for the association. Were there concerns about merging these two associations?
Well, I think at the time there was probably concern on the part of by then it was in the Academy of American Hospital Attorneys. They were going to lose their funding from AAHA.
The Hospital Association.
Right, so that would be one concern right there. There wasn't much concern on the NHLA side. Thought it was a good idea. We already, at the time, when I was president, we had 7,500 members, or 7,000 or 7,500. The AHA or the academy, was pretty static in terms of the membership. And at the time we were in NHLA, we were even accepting accountants and consultants, non-lawyers, as associate members. And that further enriched the organization.
So what was the impact of the merger?
More educational programs for everyone, and more sharing of information. It worked very well.
Tell us about the cultures of the two associations before they merged. How would you describe the culture of each one first?
The NHLA culture was really about education and getting information out to the members. The academy, I think they were a little more competitive in terms of the relationships between attorneys. Good friends they shared, but if it's somebody across the country that you didn't really know, there wasn't much sharing.
And when they merged, what was the culture that was created?
I think the culture is what it is now. It's educational and a lot of sharing of information.
Okay, now talking about the association I mentioned to you before, I've heard you have some incredible stories, some great stories. Tell us, you staged a mock funeral at one point. Who was it for?
For me.
Oh, okay.
Yeah, it was my funeral. And so the opera company in Baltimore built a coffin for me. And we had they have what they called Arabbers, which would be a colorful cart pulled by a horse where they sold vegetables. And that became the hearse. And we had 2 mounted policemen leading the parade, and then behind it we had 100 mourners and a Dixieland band, and ended up at not surprisingly, at a bar that had a lot of room. Why did I do it? I didn't want to miss a good party, so if there was after I was gone, they had the party, I'd miss it.
And what was the occasion for this? Was there some reason why you...
Oh, that was my 70th birthday.
And also, there was something involving Bromberg and an expensive bottle of wine that drove David Greenberg up the wall.
Right. Well, it was a bottle of, it was at the Tax Institute in New Orleans. And we were at the Meridian Hotel having dinner with my wife, David, Bob Bromberg, and myself. And Bob orders this bottle of 1929 Haut-Brion, which I didn't see what it cost, but even then it was probably several $100s, particularly on a hotel wine list. And of course David had no idea what it was until he got the bill, and who went absolutely ballistic. And Bob said excused himself and had to leave, and I'm there stuck with David going berserk. It was quite an evening.
Were there concerns about funding at that point, or no?
Well, the concerns about funding at that point, I think that might have even happened before, or just after the Medicare Institute got going, and NHLA was having a problem with funding, and since we were getting 800 people at the Medicare Institute, that helped the funding, and through the summer, that was always in March, and that helped at the time. That the organization was not in a position where it could afford 1929 Haut-Brion.
Right. Okay. You have had some important cases in your life, and one involved the U.S. Supreme Court, Justice Kennedy's first case. Right. Tell us about that.
Well, it was I had a series of group appeals where hospitals would challenge like the medical device manual provisions. And this was a jurisdictional issue that went up to the Supreme Court, and it was Justice Kennedy's first opinion was unanimous in my favor. And years later, I was at a reception when Justice Kennedy was there, and after everybody went up and said, saying, well, I clerked for so-and-so, and that sort of thing. I was the last one in the room, and I went up and I said, Justice Kennedy, I argued your first opinion. And he said, oh my God, I couldn't believe it. They're asking you all these difficult questions, and it was my opinion. And I thought they were going to change their vote on it. So that they were just really pulling his chain so that it was very interesting. I thought the questions were difficult at the time.
And jurisdictional meaning that...
Whether the court would accept the case.
And you also went to the Second Circuit and got them to declare provisions involving coverage of investigative medical devices.
Right.
Arbitrary and capricious. Tell us what's significant. What you...
Well, there are two ways they could have ruled. They could have said it was legislative rulemaking and it wasn't proper and had to be in the Code of Federal Regulations. The other way they could knock it out was arbitrary and capricious, which is what they found. And it's very difficult to get the courts to rule on government rulings or rules as being arbitrary and capricious. They'll find out some other way to deal with it. So I was very pleased with that. That was the Yale New Haven case against Bowen, I think.
Another interesting thing you talked about in your audio interview were the unintended consequences of the Medicare program that led to escalating costs. Tell us about that.
Well, that started early in the program with, for instance, with physician fees. It was a reasonable charge, which was the lesser of the physician's actual charge, their usual charge, or the customary charge in the community for that particular fee or particular service. And so the data that they used to determine whether there was a reasonable fee was 18 months old. So as a physician, if you wanted to get paid more, you had to plan ahead 18 months and raise your fees now to expect to get an increase in your fees in 18 months. So that was an automatic ratchet upwards. The other thing that was a real issue was cost reimbursement. And the hospitals, in this instance, would get paid the interest and depreciation, the interest on the bonds that they issued to build a new building, and depreciation. And they would not have put out that much money, but they're getting a lot of money coming in based on the Medicare payment of its share of interest and depreciation. And all they had to do was meet the bond requirements. So the efforts to halt that came through, at first, through certificate of need, where the states would have to have the certificate of need for a new wing or a new building, that sort of thing. And then they went into the DRG payment system after that.
What's an RG payment?
Well, that's where I think it was Yale, put out a study on what it costs to treat a heart attack incidents.
So they weren't padding it with efforts to build a new hospital wing or something
like
that.
Right. So that's when the hospital started. They knew they were going to get X dollars for that admission, and everything included in it. So that they started discharging people quicker and sicker, they called it, so that they put them out. But all of this sort of thing benefited in terms of attorneys and practice and the AHLA organization. More and more people got involved in representing hospitals because it became very complex. And the lawyers got involved, and then again with the sharing by the two organizations, it was really helpful to the attorneys practicing this sort of thing.
Another area that you talked about I found intriguing was the Justice Department found that billing errors could be considered fraud.
Right. Well, once once they realized they could get treble damages for fraud, and what used to be just truly would be billing errors. There was certainly fraud around, but a billing error, they would claim that it would be fraud, and the hospitals didn't want to litigate and be found guilty of fraud, so they would settle, and settle maybe at double whatever the loss to the government was. And that, again, got more and more members of the organization involved in representing the hospitals.
In the history of health law, what do you consider the milestones?
Well, my tendency is to look at, there are two. One was the Medicare program is probably one of the big things, but that's where my area of practice centered on. The other thing that was very big for a while was corporate reorganizations. And that got attorneys in other parts of the law firms involved, the corporate people, and made for a much broader practice for a law firm to be involved in health law.
And how did the AHLA and the predecessor associations, what role did they play in these milestones?
Well, they would be putting on programs with, for instance, on corporate restructuring. And that would be a large part of the tax seminars, because it would always usually be nonprofit organizations. And they'd have a parent holding company, then you'd have the hospital, and then you'd have various organizations within that corporate family. And you had to draft documents, that sort of thing. And all of a lot of the programs, Medicare program, we'd have stuff on it. The tax program would have stuff on it. The annual meeting would have stuff on corporate restructuring. So it became quite an important thing.
Health law has undergone incredible evolution over the past 50 years. On this 50th anniversary of this association, how do you see the future?
I think it's probably the payment side of it is going to be even greater than impact on the practice of health law, because you've got an aging population with the government trying to hold down the costs. And there will be pressure points, and those pressure points are going to be litigated. And there will be a lobbying that'll be involved. It's going to be a very broad area of practice.
What challenges, opportunities do you see in the future?
Well, the opportunities are endless in terms of the practice involving the Medicare and Medicaid program. And when you have things like the Affordable Care Act, that will involve other parts of the profession. So I think the opportunities and challenges will all revolve about money. And I think that's going to be an issue, because there won't be enough of it.
What has your involvement in this association meant to you?
Well, it basically built my career. I put together the Medicare program as a result of speaking at it and being the co-chairman of it. And I've got all sorts of opportunities of representation. I had group appeals with anywhere from 80 to 200 hospitals in various appeals, and it was made a big difference in my career.
And the Medicare program has been huge for all of the attorneys involved in this association. I mean, what do you consider your greatest accomplishment?
I think probably chairing the Medicare program, coming up with programs that would be useful to the members of the organization.